Good evening and welcome to the Square. It's been a while since we've been here due to some of the games that were happening the last couple of weeks, but it's a pleasure to be back on air with you. Tonight is a very important discussion that's going to focus on bail and pre-trial detentions, looking at some of the challenges and offering a solution-oriented conversation to issues that are faced in the justice sector. We're also going to look at mediation as a tool of reducing the backlog of cases in the court system in Rwanda. Generally speaking, we're here to look at these issues, and with us we have our experts from the legal field. And once again, I'm going to thank our guests for being with us tonight, especially Mr. Moise Nkundabarachi. I think this is your second or third time on the show. Always a pleasure to have you here sharing with us your expertise in the legal field. And Mr. Moise is a partner at Trust Law Chambers. Moise, great to have you on the Square once again.
Thank you.
We're also joined by Faustin Husi, who is the National Prosecutor, as well as a spokesperson at the National Public Prosecution Authority. Mr. Husi, great to have you on the Square.
Thank you so much.
Great. My name is Diana Mpisi, host of the Square. As always, I'm joined by the Square resident panelists. And with me on my left, I'm going to welcome Berna Namata. Always a pleasure having you on the show, Berna.
Thank you, Dan.
And always with us, Charles Haber. Great to have you on the show.
Same here, Dan. I missed you guys.
I missed you too. I missed you guys. And I hope our viewers missed us. Usually we go into midweek highlights to just touch on a few important topics that have interested the Squares and panelists. But because the show is quite a meaty one, we're just going to dive straight into it. And the first issue that we're going to start with is pre-trial detentions. This has been an issue, something that also during the Judiciary Week that happened last year was something that was highlighted as an issue. And in November 2020, a special committee was set up, a task force was set up to look as to issues of pre-trial detentions. These are long correctional facility stays preceding the suspect's trials. In some cases, a pre-trial detention can actually equal the sentence handed to the person speaking of. And what we want to understand is, and the question will go first to you, Moise, and also to the spokesperson from MPPA. What are the issues? Why does this happen? What are some of the loopholes in the judiciary system that allow for these long, lengthy pre-trial detentions, unjustified in some cases? And if you could just start by giving us a framework as to why this happens, and then we can look as to some of the remedial elements that are taking place to correct this. And Moise, I will kick off with you.
Thank you, Diana. First of all, pretrial detention should be understood as the period that someone is detained before he is heard in the merits of his case. And this happens most of the time when an investigation is initiated against someone, and most of the time it starts with the arrest that is carried out by the Rwanda Investigation Bureau. And from this point, when someone is arrested, then I would say that the legal battle then starts from the one who is arrested fighting to seek that he can be released. And sometimes when the Rwanda Investigation Bureau thinks that there are serious grounds under which someone should be detained, then takes on the file to be submitted to the prosecution. What we can say at this point is that the fact that normally, when you look at Article 66 of the Rwanda Criminal Procedure Law, it's a principle that someone, whenever suspected, should be investigated and prosecuted while being free, when he is not under detention. But there are circumstances under which someone may also be prosecuted when he is detained, he or she is detained, depending on whether there are serious grounds or not. But this is an exception, and this should be considered and being taken into consideration as an exception and should be considered as a last resort when you look at different instruments, including the UN Committee for Human Rights, the recommendations. When you look at the law, at the law itself in Article 66, the Rwandan law, I'm referring to Rwandan law, but there is also some international instrument, a number of international instruments that refers to this pretrial detention as something to be used as an exception and as a last resort to be considered when someone is investigated and prosecuted. So maybe we tackle the whole process, the way it happens, just briefly. First, when someone is arrested at the level of Rwanda Investigation Bureau, the Rwanda Investigation Bureau officer will be having like 5 days to carry out their own investigations and then submit the file to the prosecution. Then at the level of the prosecution, they also have 5 days, and then from the prosecution, there is a request from the prosecution to seek a detention at the level of the court. But they also, all these authorities also have the possibility of releasing someone who was detained on bail, or even put some conditions depending on the circumstances of the case that is being handled. So, we see that most of the time when a case has taken these kind of steps, it gets to the court, and the court is asked most of the time to make a decision whether someone should be kept in detention for 30 days so that further investigations can be carried out, or should be released. Then here, there is a hearing that takes place when the defense counsels and the prosecution are battling, trying to get a decision from the court on one side of the defense, people are seeking release, but on the other side, there is also the prosecution, which is seeking most of the time the detention of 30 days. But the truth of the matter is, our law, when you look at Article 96 of the criminal procedure, you will see that even after those 30 days, when the file is already sent to court by the prosecution after preparation, this person will stay in this state of being detained, which is something that most of the people do not understand. When someone is detained for 30 days, and they see that, for instance, maybe a period of 2 to 3 months, up to 6 months maybe, is also passing without him being released, yet they knew that someone was detained for 30 days. So this is the reason why a detention might go up to a period that is beyond the 30 days that are provided for by the law. But the issue here, and the problem that needs to be looked at, is the fact that since someone can also be investigated and prosecuted while free and out as a matter of principle, that is provided for by international instruments, including the Rwandan laws, quite a number of instruments provides for this. Why should someone be detained when we do not know yet whether he committed or not the offense that he is being investigated or prosecuted for? So, and the risk here is, most of the time, you will see that someone might be under investigation and then detained provisionally, and then at the end of the day, after a period, I would say, if you look in our system, most of the time it might vary depending on the case and the court to which it's going to be submitted. It might, but sometimes it can get to 6 months. Then, let alone the court decides and we find this guy or someone who was being prosecuted is an innocent. Then this guy, we have to get out of the prison and walk away happily without any sort of accountability to be asked. But the socio-economic impact of this on the other side is also huge.
Absolutely.
which is maybe something that we elaborate more by the time we'll be getting into the conversation.
Absolutely. And thank you for that general perspective, Moise. Here on behalf of the National Public Prosecuting Authority, we have with us Ms. Tonghusi. Thank you once again. Same question directed to you. Why does this happen? Why are there unnecessary lengthy correctional facility pretrial detentions? And if you could just give us, from your perspective, why this happens, so viewers and us on the panel can understand this issue more.
Thank you very much for the question. Maybe let me start by saying that under international law, international humanitarian law, the principle is that a person should be prosecuted or investigated while he is free. And the right to freedom is a right that is absolute and inalienable under international humanitarian law. But there is some exceptional circumstances where a person can be prosecuted while he is detained. Of course, you have to have serious grounds that permits you or which are serious and necessary to make sure that this person can be investigated while arrested, regardless of the principle that you have to be investigated while you are free, as per Article 66 of the Criminal Procedure Code of Rwanda. This is the principle. And we have to remember also that this detention and the pretrial detention, it is a formal detention. There is a document signed by the Rwanda Investigative Bureau, the investigator and the prosecutor, who also takes you to court for pretrial hearing. Then there is a court order that takes you to jail to stay for 30 days in a prison while the investigation is going on. So first of all, we have to understand that this is a formal and positive court order that takes someone to court. But of course, we have to remember that this has to be done under exceptional and serious circumstances. So it may happen, this is true, that someone may stay longer in prison. But of course, his detention it's a legal detention. It's not an illegal detention because of that court order. And remember that as the Criminal Procedure Code provides, for the petty offenses, the person needs to stay in prison for 30 days, not renewable. 30 days, and a decision has to be taken. Prosecution cannot renew that decision. And of course, that person is detained, he has to wait for court to fix the date of hearing, which is, of course, that's when it happens that someone can stay for 60 days, of course. But of course, as I have just mentioned, the detention is a formal and illegal. But for the misdemeanor, you go up to three months. So petty offenses, which can go to, the sentence is up to two years. Then the misdemeanor is up to 5 years. 3 months in prison, waiting for a court hearing or in merit. But also for the felony cases from 5 years up to, it can go to up to life sentence. Here you can go up to the 6 months. You stay in prison for 6 months. You can renew from 30 days up to 6 months. So from that time, you cannot extend that detention, that pretrial detention. So the issue of staying longer in a prison normally comes when the people are waiting to fix their dates for the hearing. This is an issue. And of course, you cannot say that this is that arrest, that pretrial detention is an illegal, because there is a document, there is a court order, there is a court decision, which of course has to be adhered to. So this is what I can just say. Maybe I will talk something else after.
Thank you very much. I think we have more questions than answers, but thank you very much for sharing, just giving us a good idea, understanding of the framework behind this. But I think it still raises more questions than answers, and I'd like to just put this to the panel. Charles, I'll kick off with you.
First of all, I think I need to give credit to where it's due. By virtue of the fact that we're having this good discussion, it means there's legal progress. We are progressing as Rwanda. The square is more than 3 years old. We're having this conversation. We have had Diana, and I'm sorry to disarm you on this, but I know you have run into walls in terms of having this conversation. But by virtue of the fact that we're having this conversation, I think it's credit to the Rwandan judicial system. That's number one.
And the Rwandan media space.
The Rwandan media space by default.
Yes, by default.
Yeah.
Yes.
So, Musi and your team, congratulations that we are able to have this conversation.
Really?
Number two, well, no, I know, Bana, we frequently disagree, and it's good. That's number one. Number two, why does it have to take this long for us to have this conversation? And I will strongly disagree with Musi. You see, the moment you're going to use the arm of the law to say you will be arraigned after 20 days because you scratched my side mirror. You're going to be arraigned after 3 days because you are caught drunk and driving. You're going to be arraigned after 5 days because you're suspected that you stole money from the East African. The moment it starts being subjective, there's a problem. Now, and I'm sure that's where the problem is, because pretrial detention should not be subjective. And that's where the gist of the matter is. We have, as a country, taken magnificent strides in the judicial sector. Back to my earlier point, we would never have had this conversation 5 years ago. We have this conversation today because of the likes of Musi and Moise. So that point should not be taken lightly. But I want to take prosecution to task. Then let's take this to a notch higher. The government of Rwanda and our rhythm on the square is institutional coordination. Just this week, we've passed our legislation around investment promotion, and we have done a lot of business reform around quite a number of things. Let's ensure that from a legislative perspective, that people, and I know, and I want Moise to talk about this as the show progresses, that civil matters are not put into criminal perspective. So, and I'll give you a practical perspective that my very good friend Musi raised. We because all he said was time, and with all due respect, you've made magnificent progress. You know, time has been magnificent. However, when are we going to get to a point when we look at a case in its merit, Diana? And can we get, so if you look at it's going to be a little bit painful to say this, and Moise, I will beg that he does not give specific examples. When we want to take strides as a business, destination as a country, can we ensure that we do not pain business people just because of Nhusi's procedural pains?
Okay.
Yes.
Well, that's a lot to take in, Charles. I'm going to just pass on for Brenna, but I'd just like us to, and before we go back to you, Moise and Mr. Nhusi, I think what we'd also like is to just hear more on not just the framework as to why this happens, but looking forward, what solutions can we offer, or what solutions are actually in the pipeline to ensure that these pre-trial detentions that, you know, you kept on talking about 30 days renewable again, but we have people we know who, for issues that are not criminal cases but civil cases per se, in pre-trial detentions for almost a year. So I think what I would like to steer the conversation on from a legal expert point to you, Moise, and Nhusi, is what issues are in the pipeline? Sorry, what is in the pipeline? What changes can be effected to make sure that this issue is something that no longer happens? Brenna, over to you.
I just made a comment before the show to Moise and said it's difficult when you have two lawyers in front of you because they always have some law, some article to refer to for whatever statement you make. So I will limit my comments to what any ordinary person would say without understanding of the law. Yeah. So one, there is, generally, I think we will have to accept this. There's public outcry over this issue.
Absolutely.
So there is a problem. I don't know what it will take to fix, but there is a problem. So whoever is in charge, I think, has to do something about it. Secondly, I think we need to look at the bigger picture of what the public outcry tells us and how it affects the other aspects. I work with colleagues across borders, I have colleagues around the world, and one thing most of them have in common is they come from quite, they say their society is, the word is litigious, so people will sue you for whatever, as simple as wrong spelling, wrong reference, someone will sue you for whatever. Now, so when you compare with Rwanda, we are not there yet. In the region, I think we are yet to come to a level where people will actually aggressively pursuing their rights to that level. Now, if you look at the outcry that we're seeing, they are grieved. Imagine if everybody was to say, I'm suing for illegal detention. What kind of, what we would have. So that is not happening. So maybe food for thought for the judicial sector is to think about if there is an awareness and it leads to that, why you have several cases coming up and people are suing because they think they were illegally detained. He just said there's nothing like illegal because, there's always a file. Yeah. But I think we need to have that in mind and prepare for a time that will come when people will actually pursue that right Currently, we haven't seen as much litigation against whatever is happening.
If any at all.
Any at all, yes.
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 But it can happen because, again, as he pointed out, there is a provision for it. Why it's not being done is a completely different issue, but it doesn't mean it will not happen. At some point. It's going to happen. And thirdly, I feel that the law society is not doing us any good.
Law Society being the Bar Association?
Yes, the Bar Association. The Bar Association is not doing us any good. And I don't know why. Because if there's a public outcry on an issue, we have not seen a position paper from the Bar Association, to at least in interest, in public interest.
Absolutely.
To make their position clear. Then I don't know what the lawyer's oath says, but they owe it, to the citizens to explain what is happening. Because there's an issue, yeah? And as the experts, I think they must do something about it.
Over to you, Moise and Nkusi, and Foster Nkusi, I will kick off with you. You've heard from the panel some of, there's a public outcry. It should not be an issue of subjectivity. It should not be, it should be across the board. Why, you've explained to us the why. How, or can you explain to us any ideas you have based on your background or in your field in terms of remedial actions that are in the pipeline or can be applied to ensure that this is not such a major issue as it has been in the last 2-3 years and is generally on an incline. And here I'm referring to lengthy pretrial detentions that sometimes not only outweigh but also measure up to the actual sentence given, at the end of the day. Foster, over to you.
Thank you very much. Maybe let me clarify first before I proceed. Pretrial detention is not an illegal detention. That should be clear, as I said before, because this is...
I will disagree.
I disagree with you. I think I have the right to disagree and, of course, explain why.
Yes, absolutely.
Yeah.
Absolutely.
Because we cannot continue saying that pretrial detention is an illegal detention, because this is a formal detention, which is taken by a formal authority. There is a court decision. There is a court hearing that has taken place. And there is a court decision ordering the person to be detained provisionally or to be in a pretrial detention. So I think we should avoid using the illegal...
Let's not be misled.
The illegal detention...
Charles, let's...
the illegal detention we're talking about here, that is, if you commit an illegal detention as an individual, that is a crime, by the way. It should be known. If you arrest someone illegally, it's a crime, and you can be investigated and even be prosecuted. So whatever you're talking about pretrial detention, this is not an illegal detention. It has to be clear. Because the person who commits a crime of an illegal detention, there is a principle of habeas corpus. You are taken to court and explaining why are you detaining the person illegally.
But Mr. Nkusi, I think I would just like to clarify also on behalf of the show and the panel. I think we understand that pretrial detentions are not illegal.
Okay.
We're not saying that they're illegal. No. I think let's just clarify that. What we're saying is that how come they are lengthy? You can have someone detained for 2 years. And there's just a backlog of cases. And Moise talked about the socioeconomic repercussions of this, the mental repercussions, physical, of the people who are detained this far. What we're trying to understand is not that it is illegal, but why does someone before going to trial have to be incarcerated or detained for over a year? Like, why in the judicial system this is an issue? There's been a public outcry, and what we're trying to understand is how can this be remedied? How can this be eventually something that can be worked on? But I think I just want to clarify that we understand that pretrial detentions are not illegal.
Okay, I think there is something I can explain in our criminal procedure code. Someone who has stayed in a long period in prison can still request for the court to release him. There's a provision in our criminal procedure code, which is, that's can also be another way of, or another remedy for that person to ask for the court to listen because he or she has stayed in court for quite a long time. Of course, waiting to be tried by court. Yeah, so maybe...
I think we're being taken for a ride.
maybe let me also
Let
say
him
something.
finish and you will have your chance, Charles. Yes.
Yeah, maybe let me finish and then we'll proceed. To give you maybe some clarifications again, let me give you some figures to understand exactly what I remember Haba said that there's a progress. Of course, the progress is there, and we should also appreciate that because something is being done a lot by our judicial authorities and the judiciary in general. I just want to give you, you will allow me to just to read because there are figures, statistics from the prosecution.
Please. Go ahead.
Yeah, I just took like only 3 years, starting from 2017 to 2020, by explaining the number of cases that you received by prosecution, measures taken, and the decision taken from those cases. From 2017 to 2020, we received 141,701 cases in 3 years. If you look at this figure, these numbers, we filed to court 97,691 cases to court. And there is another figure of 42,484 of cases that were closed. Closed means no investigation. It means you have investigated, you have done your investigation, and you find that there is no need to go further with this case. The case is closed. 42, more than 42,000. Then we are coming to the issue of bail and release. This is where at least people should also understand. We released more than 8,347. These were released by prosecution, released on bail and other conditions for 3 years. And of course, this figure, these people were released, but also we filed the case to court for hearing. It means that they were investigated when they were not only pre-trial detention. This is what it means. And then we have another figure of 16,266 released by prosecution, but also closed the cases, no further investigation.
But do you realize it does not give us the figures of those who are arrested?
I think
they are there.
Yes.
No.
I'll come to that.
In relation,
You'll come to that, yes.
No.
Yeah.
In relation to those who are released. So I would be happy if that sheet of paper gave us percentage of released on bail in relation to arrested.
I think when I mentioned something like released by prosecution, released by court, some are released on bail, others are released on other conditions. Okay? So as you can see the figure, it's a very big figure. You cannot say that 3 were on bail, other, I didn't go into the rest, but you should answer that those who were released on bail are also part of this.
So the biggest question is arresting versus releasing.
And by that you mean what exactly?
Yes.
How many were arrested? And
yes. So they are quick
but
to
maybe
arrest.
I haven't finished. Maybe you were.
Yes.
Okay, no.
Yeah,
I'm sorry, Mosi.
I think
I only remain with one point here.
Yes. Okay. Carry on.
I am sorry.
I'm coming to your point now.
Yes.
To your point of those who were detained on pre-trial detention.
Yes.
Okay? I think that was your question.
Exactly.
Yes.
So these are 33,395.
Okay.
Okay? So I wanted just to put these figures in the front of you so that you can understand what is happening, what are we doing, and what is the progress. So it implies that there are people who are released on bail and on other conditions, and the others are taken to court, of course, detained on pretrial detention, which is of course, as I said, a formal detention and illegal.
Thank you very much. But just very quickly, unfortunately, I think we had two aspects. We wanted to talk about bail, we wanted to talk about pretrial detentions and mediation, and we're really running out of time. So, Brenna, I want you to be very quick before I go to Moise. And Moise, what I would like you to discuss is just really a solution, because we keep on going around the circle. I feel there's pretrial, there's bail denials, there's this, there's that, but is there light at the end of the tunnel? How can we approach that light? And that's what I want you to focus on when we come back to you, Moise. Brenna, very quickly, over to you.
Yeah, very quickly. I just wanted to follow up on the statistics that he's giving. I wonder if he has statistics on compensation, for those that eventually do not end up. Do you track compensation
for those that who are now deemed innocent?
Yes,
who are given an innocent verdict.
Yeah.
And before Moise comes in, I doubt Moise's figures.
Okay, Lucy, very quickly, is just to the question of compensation. Is that something that's happening on a large scale or not?
Can she explain more, maybe?
I think what she's asking is in the eventuality that people are found innocent, even though they have gone through a lengthy pretrial detention, at a long stay at a correctional facility, are there measures of compensation to these people? You find someone who's been detained for 8 months and then eventually they're found innocent. Is that an element of compensation?
The law does not provide for that compensation, and I think it is a general issue under international law. It's not an issue of Rwanda only, but because we have had some cases in other countries. Of course, some countries they do provide for that compensation for the time spent in that pretrial detention, but our criminal procedure code does not provide for that. Of course, when the person is acquitted, he just goes at home and then,
Thank you. Moise, over to you. Light at the end of the tunnel, what are your ideas on how this issue can be fixed? I know it's not a silver bullet, but I'd just like to hear from you on this.
Yes, maybe to come back to the context of the conversation. Like the way you're putting it, the issue here is to know whether we can have alternatives to pretrial detention. And this will actually lead me to the solutions that can be provided, which actually are also provided under our criminal procedure law. But then the issue becomes the practice and how these instruments are implemented by the time it gets to practical cases. I would say, coming back to the conversation of alternatives, if we apply this principle of investigating and prosecuting people while they are outside, they are not detained, this is something that is provided for by the law, and we can set up and put up a kind of system that allows this kind of practice to be developed. When we have this conversation with a number of the people in the circles like RIB, prosecution, and when the cases get to court, most of the decisions on detention will be like, no, you should be placed under detention because we think you're going to run away. Second, because we are not sure about you being available whenever we want you. And most of the time, there are two reasons that are provided. Yet, most of the time, like in this near future, the cases that are being handled, this person that is told that they are not sure whether he's going to report was called over the phone. He reported to RIP 1, 2, 3 times, and the first time you're told you're under arrest. Again, maybe to understand this issue very well, a decision from someone who is suspected maybe to decide that he's going on the run, it's not something very easy. This is something that these institutions has to understand. It's not something very easy that someone can take a decision that I'm going on the run. It's especially for people who are established and who are doing most of the time either business or, but it has to be looked at to have an outlook of a general thing. Solutions. When you get to these solutions, you will find that there is a way, what we call judicial control. A decision might be taken that someone is released, but given conditions that, like for instance, you're not allowed to go out of Kigali. Someone might be released, and I know this is in pipeline, and somewhere else it's done, and be monitored by a bracelet or an ankle monitoring.
After all, we're doing it for COVID.
Exactly.
Yes.
Yes.
Someone might be released and be requested to pay a security or a bail. This is provided for by the law. But it happens that even people do propose or suggest these kind of bails, and the judge will tell the one who has suggested this kind of bail that, no, this is it's like, it has to be in the assessment of the judge at his or her own discretion. And then he is denied the release because simply the judge thinks this one has to be sent to prison prior to his case in merit to be adjudicated, so that we can get to know whether this person has really committed this offense or not.
Moise, I'm going to ask you to just quickly speed up because we'd like to read some of the tweets from our guests, but we're really on track with you in terms of the solutions that you're talking about.
I'm almost like getting to the last part of the solutions that are provided. One, if you look at all these like worry from these institutions that someone can run away, someone cannot be found, there is quite a number of I would say, solution to this. Even though someone runs away, this does not stop the criminal process to happen. You can be judged in absentia. These institutions that are in charge of law enforcement has a whole mechanism around Interpol that can bring anyone back whenever you're on the run.
And we have brought them.
This institution that my colleague Musi is representing
is lazy.
have been very efficient.
Do you think it is not easy?
In tracking the fugitives around the world. So there is no single reason why they should worry about someone who has gone on the run simply because he gave a bouncing check in Kigali of 5 million.
Absolutely.
So
can I say something?
Maybe lastly, what I want to say is that there is always an alternative to this pretrial detention that can cost us less than what it costs when someone is prosecuted while being in detention. Absolutely. And ends up becoming innocent. Because at this point, we do not know yet.
Exactly.
And these institutions can be much more efficient carrying out investigations when someone is at ease without even his knowledge. And then whenever they feel like we have enough information, the arrest happens, and then even the trial will be speeded up. Because there's no more need of seeking these 30 days and the 10 days that someone has to have to spend between RIB and...
Moise, thank you very much. Ms. Tanghusi, less than 30 seconds to get your point across, because we'd really love to hear from our viewers.
Thank you very much. I just want to say something on what my colleague just mentioned regarding someone who was evaded. Justice went outside the country, and he says our institutions and are able to track and don't think it's something very easy. Tracking someone, getting information about him, and bringing him back is not an easy task. However, I do agree with him that it should be a principle that someone should be investigated while easy free. But we can also not avoid the pretrial detention for some cases where we deem it necessary.
Absolutely.
And where we think we have absolutely sufficient grounds.
Should be an exception.
To put that.
Thank you. And thank you, Foster. We totally agree with you. We'd like to just quickly go to our Twitter feed. There's lots of views coming in that we'd like to just read in the last 5 minutes of the show. And the first one comes from Keza, who says, not everybody who is incarcerated in a jail has been convicted. Mr. Nhusi, so why is pretrial detention and pretrial release such a very hard thing in Rwanda, given the amount at which bail is set is important? So she's talking about pretrial and bail. And in a nutshell, we have also from Bujingo, who says that detention may be illegal without being arbitrary and vice versa. Illegality simply means that the law has not been to be complied with, whereas arbitrary refers to inappropriate, unjust, unforeseeable, or disproportionate nature of the detention. Yes, great point from Bujingo. He also continues to say that, if we can have that on our screens very quickly, once a person is legally arrested or detained and continues to be detained beyond the numbers of days that the law prescribes, such an action becomes arbitrary or unlawful. More tweets coming in. We are just going to quickly go to just very quickly, the other tweets that we're getting in on this topic. We have one from David Butera, who says that the argument is not even whether lengthy pretrial detention is legal, but is it fair, especially for those that are innocent. I think this is something that we've already covered in terms of understanding that there are exceptions and also giving solutions to the lack of, it's not necessary to always incarcerate or detain people pre-trial as a solution. We also have another tweet coming in just very quickly from Jackson Seminega, who says that, great show, a question to the two gentlemen in the law field. Is there any law in Rwanda that allows citizens to sue the police for any wrongdoing, including the matters that you're talking about? And this is what Berna was referring to in terms of compensation. You know, if you're wrongly accused, wrongly detained, is there a level of compensation? Are you allowed to legally, litigate, go for the judicial authorities in this field? And then last, we have from Bujingo says that method or process of thinking that someone is a flight risk or will distort evidence and that therefore should be detained while investigations are carried on may be a pretext to encourage unprofessional conduct by officers in charge. And he says, in quotes, sufficient grounds, subjective. Absolutely. Closing remarks in less than a minute. I'll just give you, Charles. Please, Charles, don't take your time. Wrap it up. I know this is something you're passionate about. You're in the law field. Yes. But in the interest of time, just
I'm extremely passionate about this field, not only because of my legal background. It's predominantly about my business background.
Okay. That too.
I think we have made significant grounds in terms of attracting investments to Rwanda. Mm-hmm. Let the judicial sector not let us back. Mm. There's nothing wrong with granting bail. It's not a criminal offense. A prosecutor should not be made to think that he or she will lose her job because he or she granted bail to Moise Nkundabarashi. And I think that's where the problem lies. Mm-hmm. Bail is a constitutional right.
Absolutely. Yeah. And that needs to be applied. Werner, very quickly. Closing remarks.
As Charlie said, there's been a lot of progress. I mean, when you come to think of it, Rwanda abolished the death penalty. Now, we still have countries that are in the business of human rights that still have the death penalty. Yeah. Now, when we come to things like bail, surely, if you can abolish the death penalty for crimes actually that deserve death, then I think we really need to reconsider, and send a message that bail is possible. And this whole business of making it difficult, should be looked into. It's a serious issue, and as Charlie said, it affects investment, it affects across sectors. It shouldn't just be looked at in the sense of, just one particular field. It affects the destination as Rwanda.
Especially when you look at investors and coming in, and you mentioned this, the rule of law, it has to be something that also allows some of these issues to... Charles, I think I feel like
we have just passed
you're hogging this show, Charles.
Beautiful...
yes. Charles, please.
Legislation
yes.
on investments.
Investment promotion.
Yeah,
yes.
it just came out this week.
Yes.
It will be shooting ourselves in our foot.
Yeah.
If we cannot address the bail issue.
Absolutely. I would like to go to our guests. Closing remarks very quickly from you, Moise, very quickly, and then over to Mr. Foster in less than a minute, please.
Thank you very much, Diana. This is a very complex topic that cannot be discussed within an hour.
Absolutely.
But we do understand that even the national television has its own schedules that has to be respected. So, concluding remarks. In my understanding, in as much as my colleague has put it that a lengthy pre-trial detention is always legal because there are documents justifying a detention, when it's overdue, it might also in one way or the other even contravene the Constitution in as far as due process is concerned. So we have to understand this. And again, I do agree with him that at any level of the process, someone can ask to be released. This is provided for in Article 96 of the Criminal Procedure. So basically, what I would like to just mention is the fact that pre-trial detention has alternatives, and these ones are to be applied so that the judiciary is not the one to be stayed behind while we are developing it.
Thank you, Moise. Very, very quickly to you, Mr. Foster.
Thank you very much. Bail is provided by the law. Our criminal procedure code provides it, and
give it to everybody.
We have been applying it, and what I can say, it's not sometimes not automatic.
Okay.
Because it has to be evaluated.
Thank you very much, Mr. Foster. To you, Moise, thank you very much. Thank you very much to Charles, to Bernard, to our viewers. Keep the conversations going. I really feel really pressured because it's a very, very nice topic, but less than an hour, I think it's impossible. We need a part 2, part 3, part 4. But thank you very much. And keep the conversation going on our YouTube, The Square Rwanda. There's a live chat, so keep the conversation going, as well as on our social media, Twitter feed. I'd like to thank our partners, Uzi Collections and Bourbon Coffee. Thank you very much for always supporting The Square. To our viewers, have a good night. Thank you for tuning in, and see you again next week.